My name is Smit. I serve as the Executive Director of Cause for Justice. We work to ensure that matters of public importance receive careful constitutional consideration.
My name is Afrika Mhlophe. I'm speaking as someone who believes that decisions affecting children, families, and schools matter deeply because they shape the kind of society we leave to the next generation.
Today we want to talk about a case that reaches far beyond a single learner, a single family or a single school. What happens when a court case involving a single learner and a single school has the potential to influence education policy across an entire province and even the country? Many people assume that disputes between a school and parents are private matters that only affect that immediate school community. But every now and then a case comes before the courts that raises much bigger questions. The gender transition in schools case is one of these cases.
The case began with a boy identifying as a girl and a parent requesting the school to allow the learner to be treated as a girl in the school environment. The school did not agree to all the requests that were made and was subsequently accused of unfair discrimination. While the case originated from the circumstances of a single learner, the relief being sought has the potential to extend far beyond this individual situation. The outcome of this matter will influence how schools across South Africa respond to similar requests in future, how concepts relating to sex and gender are interpreted within educational settings, and how schools develop policies on these issues. This is the first court case of this kind in South Africa and may establish a legal precedent that affects future cases and education policies for years to come.
Why has Cause for Justice stepped in? Cause for Justice has entered the matter as a friend of the court because we believe the issues involved require careful consideration of the best interest of children and of the wider society. This case is not simply about one learner or one school. It raises broader questions that affect all South Africans. Questions about the role of parents in decisions affecting their children. Questions about the responsibilities of schools and governing bodies. Questions about the interpretation of constitutional rights. Questions about the best interests and protection of children. And questions about the long-term implications for education policy.
This case matters because its consequences will not be confined to a courtroom or in regional circumstances that gave rise to them. It matters for children, the language that they are allowed to use, being forced to share bathrooms and locker rooms with the opposite sex, and especially girls being exposed to an increasing risk of bodily injury and unfair competition in sports. It matters for parents, whether parents will be allowed to make decisions about the best interest and safety of their children. It matters for education, what our children would be taught in their classroom. It matters for teachers and schools, whether teachers will be forced to treat boys as girls and vice versa. It matters whether school governing bodies and executive teams will be allowed to lead their schools according to the religious and cultural values of their community. It matters for civil society. Pressure will follow for churches, healthcare providers, home education, and other public and private institutions to conform.
But things do not need to turn out that way, and there are good reasons to believe that they won't. The importance of biological distinctions between male and female has a history of broad societal acceptance that has shaped law, medicine, and social policy across cultures and generations. These distinctions are not discriminatory, but exist to acknowledge the real and meaningful differences between male and female, and to ensure that protections, healthcare, and legal frameworks reflect that reality. In recent years, this principle has seen significant reaffirmation across the globe. Amongst others, landmark rulings in the United Kingdom and the United States have reasserted that biological sex is a distinct and legally relevant category that cannot simply be replaced by gender identity. Cause for Justice is also defending this position. We have an established track record of engaging with government, schools, and parents in this context over the past decade. We have assembled a competent and experienced legal team to present a constitutionally sound and evidence-based case in court.
So how can you get involved? The first step is to stay informed. Understanding the issues is the first step toward meaningful engagement. Secondly, share the information with others. Help friends, family members, and colleagues understand what the case is about and why it matters.
Thirdly, support the legal effort to the extent you are able. Cases of this nature require substantial preparation, legal expertise, research, and significant resources.
Every contribution helps make this work possible. And finally, please pray with us. Pray for wisdom, truth, and justice throughout the legal process. Pray for everyone involved in the matter as they navigate these complex issues.
The matter is scheduled to be heard in the Cape Town High Court in October 2026, and significant preparation is already underway. Over the coming months, Cause for Justice will continue providing updates and opportunities for public engagement as the case progresses.
Our goal is not simply to report on legal developments. It is to help South Africans understand the issues that will shape the future of education, parental rights, and public policy, and to do something about it. Because what becomes law eventually becomes culture.